Lord, Section 8, I don't wish to, my Lord, dwell much. It merely gives an additional locus. Earlier, my Lord, what used to happen, if contracting parties are before a civil court or any judicial forum, only the party can say that send us to arbitration or send them to arbitration. Now, my Lord, even any other person claiming through or under him also can. It gives additional locus in Section 8, nothing beyond it. My Lord, it doesn't affect the applicability or otherwise of the Group of Companies Doctrine.
Yes.
Lord, page 10, para 22, my Lord, the heading, my Lord, I'll not, my Lord, dwell much, but my Lord, I'll just orally point out in 2 sentences that the very object of the Act is to ensure that dispute A is resolved fast. Second, it is not fragmented. If someone is really a part of a defined legal relationship, then I'll fight with A in an arbitration and I'll fight with C in a civil suit. That is avoided. So your lordships would avoid a meaning which defeats perhaps the intention of the legislature. Lord, now page 11. Lord, your lordships may not again read it. I'll just orally point out what my submission is. May I read, my Lord? Or
yes. Page 11.
11, para 28. Lord, the submission is that every jurisprudential doctrine may not have its foundation or basis in a statute. Lord, Lord, without reading it, I'll just orally point out what my respectful submission is. Lord, the legislature provides the letter of law.
Yes.
And your lordships, by judicial interpretation, infuse the spirit and blood in it. And that is, my Lord, the doctrinal approach. Lord, for example, doctrine of estoppel. Lord, doctrine of legitimate expectation, nowhere to be found in any statute.
Promissory estoppel.
Promissory estoppel, my Lord. There are, my Lord, the doctrine of piercing corporate veil. It's not part of any statute. Doctrine of proportionality. It's not a part of any statute that it has the punishment or act should be proportionate to what is being dealt with. Then doctrine of causes omissus. So, my Lord, jurisprudence evolves once the letter of the law is interpreted by your lordships and your lordships infuses blood and soul in that letter of law provided. If it defeats the very intention of the act, my Lord, it cannot be accepted. Suppose there would have been a doctrine in the arbitration context which would have defeated the very object of the act. Then your lordships may in a 5-judge combination say that no, this doctrine is not applicable. But it furthers, my Lord, the object of the act. It supplements the intention of the legislature. So now the question is, when there is statute silence in the statute law, can the doctrinal approach be incorporated while dealing with that law? So to put it differently, when this was an argument that when there is no reference to Group of Companies Doctrine, can you read that into Section 7 or any other provision merely as a doctrine which is evolved by judicial interpretation? Lord, there is a recent judgment of the United States, my Lord, United States Supreme Court, my Lord. And allow me to read that page 30 in arbitration. In arbitration, my Lord. Lord, therefore, my Lord, before I read it, my Lord, please examine. There are several countries broadly classified as those who have adopted the model law of UNCITRAL, those who have not adopted the model law of UNCITRAL, but all have their domestic laws, maybe fully in conformity with UNICITRAL, maybe partly in conformity with UNICITRAL, maybe completely different from UNICITRAL. Whether they can use the doctrinal approach or not, as per their domestic policy. Suppose India is UNICITRAL compliant law. Can we not have some doctrine? Lord, that is answered by the Supreme Court of United States at page 13. Lord, the citation I have given, Lord, and I have placed, Lord, the judgment also, Lord, GE Energy Power Conversion Finance. Lord, para 13, Lord, may I read this judgment? Lord? This silence is dispositive here because nothing in the text of the convention could be read to otherwise prohibit the application of domestic equitable estoppel doctrine. Now, please mark it. Equitable estoppel doctrine is a facet of Group of Companies Doctrine. I'll show you. Equitable estoppel doctrines. Because I will be stopped from saying something which I did, which resulted into a defined legal relationship. Only one article of the convention addresses arbitration agreements, Article 2, and only one provision of Article 2 addresses the enforcement of those agreements. Article 2.3, the text of Article 2.3 states that courts of a contracting state like India, but India would be a contracting state in this context, shall refer the parties to arbitration when the parties to an action entered into a written agreement to attribute and one of the parties requests referral to arbitration. The provision, however, does not restrict contracting states from applying domestic law to refer parties to arbitration in other circumstances. That is, Article 2.3 provides that arbitration agreements must be enforced in certain circumstances, but it does not prevent the application of domestic laws that are more generous in enforcing arbitration agreements. Now, please mark this, Lord. Article 2.3, that is unilateral, contains no exclusionary language. It does not state that arbitration agreements shall be enforced only in the identified circumstances. Given that the convention was drafted against the backdrop of domestic law, it would be unnatural to read Article 2.3 to displace domestic doctrines in the absence of exclusionary clause. There has to be a statutory provision excluding the doctrine. In absence, doctrinal approach will be available to the courts while interpreting the arbitration agreement. This interpretation is especially appropriate in the context of Article 2. Far from displacing domestic law, the provision of Article 2 contemplates the use of domestic doctrines to fill the gaps in the convention. For example, Article 2.1 refers to disputes capable of settlement by arbitration, but it does not identify what disputes are arbitrable, leaving that matter to domestic law. Then, my lord, some judgment is cited. Similarly, Article 2.3 states that it does not apply fails to define those terms. Again, the convention requires courts to rely on domestic law to fill the gaps. It does not set out a comprehensive regime that displaces domestic law. In sum, the only provision of the convention that addresses, dear lordships, can, my lord, lord, 14. In sum, the only provision of the convention that addresses the enforcement of arbitration agreement is Article 2.3. We do not read the non-exclusive language of that provision to set a ceiling that tacitly precludes the use of domestic law to enforce arbitration agreement. But here one can read, my lord, doctrine. There is no exclusion by the statute. Statute could have excluded. Statute could have excluded, subject to, Lord, meeting with your lordship's test if challenged. Lord, New York Convention, my lord, I have addressed your lordships. My lord, I will not take your lordships to, my lord, that. Kindly come to page 17 directly, my lords. Some of the parameters which are considered, my lord, we have examined for your lordship's assistance. And, my lord, it would be your lordship's pleasure, my lord, whether I go into this in detail or not. I may not go to, if your lordship, my lord, feel that it might unnecessarily consume time. But the exercise is this. What are the parameters considered by other jurisdictions of the world to incorporate, to accept the group of the company doctrine? It's not just a group of the company, that somebody is a company and is group company of somebody else. That's not the only thing. Lord, please come to, my lord, page 19. Representation, agency and apparent authority. often theories of agency and these are illustrative. These are not exhaustive. It would depend upon the fact-specific situation. Often theories of agency and representation are relied upon to bring an arbitration claim against a party who is not signatory or a part of an arbitration clause. Though the exact meaning of the agency and representation is different in each jurisdiction, the fundamental principle is that one party acting as an agent execute a contract on behalf of other party, which will be the principal. Then irrespective of who the signatories are, both are liable. In this kind of scenario, questions have arisen as to whether the principal authorized the agent with categorical power to enter into and bind the principal in the arbitration clause, or the power so conferred was general authority to enter into a contract which is a substantive contract. But most of the case law is on this, that I authorize my agent to enter into a contract, but my authority can be specific. That, all right, you bind me even for arbitration, or my authority may be limited, that bind me in the main substance of the contract. If there is a dispute, two of you settle. That would be fact specific. Variety of situations have arisen under this head. If from the agreement, whether an agreement in conventional sense or an act of agreeing through correspondence or other acts, expressly confers power on the agent to bind the principal, even with regard to the arbitration generally, the doctrine is made applicable and the principal is joined in arbitration proceeding and is bound by its outcome. Now, my lord, some jurisdictions have gone a step further. There may not be any express authority, but a presumed or ostensible authority. Somebody, my lord, gives an impression that I am authorized, and the principal doesn't object by his act of commission or omission. Please see, my lord, absence of actual authority in some jurisdictions, the courts are also examining whether a party not mentioned in the arbitration clause should still be bound on the basis of apparent or ostensible authority of the party which is a party to the clause or substantive contract. In the event of a party initiating arbitration against a non-signatory or a non-party, the claimant will have to satisfy two conditions. But these are the broad conditions, which are generally found in all jurisdictions when it's a question of fastening the responsibility based on ostensible authority. A, the principal had very apparently induced by way of a false representation the claimant to believe that the agent had the authority to bind it in an arbitration clause. B, such misrepresentation can also be implied based on the existence of undeniable and intricate business and corporate links between an ostensible principal and or the ostensible agency, which can reasonably lead the claimant to believe the existence of such an authority. This will again be a subject matter of fact situation in each case.